The marble halls of the Supreme Court of the United States fell silent as Chief Justice John Roberts leaned forward, his normally measured demeanor replaced by visible irritation. His gaze fixed directly on Elon Musk, who stood confidently at the petitioner's lectern in an uncharacteristically formal Navy suit. "Mr. Musk," Chief Justice Roberts said, his voice carrying through the historic chamber with unusual sharpness, "this court is not one of your social media platforms. We deal with constitutional law, not technological disruption, and certainly not the kind of showmanship you seem to believe substitutes for legal argumentation." The audience in the gallery inhaled collectively. Never in recent memory had the Chief Justice addressed an appellant with such direct criticism. Several associate justices shifted uncomfortably in their high-backed chairs. Musk, the world's wealthiest entrepreneur, remained steady. He adjusted his papers calmly, a subtle smile playing at the corners of his mouth. "Thank you for that clarification, Mr. Chief Justice," Musk replied, his voice measured and respectful. "With the court's permission, I'd like to present evidence that I believe will fundamentally change how we interpret the First Amendment in the digital age." Roberts' expression hardened. "Mr. Musk, I've reviewed your brief. What you're proposing isn't just unprecedented, it's frankly absurd. Your company is not above established law simply because you believe technological innovation demands it. What happened next would stun the highest court in the land, change the trajectory of digital speech law forever, and transform the relationship between America's most powerful judge and its most controversial business leader. Before we dive into this extraordinary courtroom confrontation, make sure to like and subscribe for more incredible stories of high-stakes legal battles that change the course of American history." Chief Justice John Roberts, 69, had presided over the Supreme Court for nearly 2 decades. Appointed by President George W. Bush in 2005, he had established himself as a careful institutionalist who valued precedent, moderation, and the court's legitimacy above ideological purity. Known for his sharp legal mind and meticulous attention to detail, Roberts had navigated the court through increasingly divisive times while attempting to maintain its reputation as an impartial arbiter of constitutional questions. In recent years, however, Roberts had expressed growing concern about the influence of technology companies on public discourse. In several opinions and public speeches, he had questioned whether the traditional First Amendment framework was equipped to handle the unprecedented power of digital platforms. The founders never envisioned private companies with more communicative reach than the government itself, he had remarked at a judicial conference just months earlier. Across from him stood Elon Musk, 53, the controversial technology magnate whose acquisition of several major social media platforms had transformed him from a business leader into something more consequential, a central figure in debates about free speech, content moderation, and the future of public discourse. After facing regulatory challenges to his content policies, Musk had taken an extraordinary step, personally arguing a case before the Supreme Court that would determine whether his platforms had First Amendment protections against certain government regulations. The legal community had been stunned by Musk's decision to represent himself rather than rely on the elite Supreme Court specialists typically entrusted with such high-stakes litigation. Legal commentators had dismissed it as another publicity stunt from a man known for unconventional decisions. "This isn't about publicity," Musk had told reporters on the courthouse steps that morning. "This is about the fundamental principles of free expression in the digital age. Some arguments are too important to delegate." Now, as he stood before the 9 justices, the stakes could not have been higher. The case, Platform Innovation Corp. v. Federal Communications Commission, would determine whether new regulations requiring certain content moderation practices violated the First Amendment rights of digital platforms. Beyond the immediate regulatory questions, The court's decision would potentially reshape the relationship between government and the increasingly powerful technology sector. In the front row of the gallery sat key figures from both sides of the debate. Technology executives watched nervously, aware that the precedent set would affect their own businesses. Government regulators and legislators observed intently, hoping the court would affirm their authority to address growing concerns about digital communication channels. The tension in the chamber had been building even before the Chief Justice's unusual rebuke. Roberts, the careful institutionalist, saw before him not just a litigant, but a disruptive force who represented everything unpredictable about the modern information landscape. Musk, the innovator accustomed to breaking established paradigms, faced a court steeped in tradition and precedent. As the confrontation unfolded, Associate Justice Elena Kagan leaned toward Justice Brett Kavanaugh and whispered something. Kavanaugh nodded slightly, his expression suggesting concern about the direction of the proceedings. Roberts cleared his throat. Mr. Musk, this court granted certiorari to address specific constitutional questions, not to entertain technological hypotheticals. Please confine your arguments to the legal issues presented in your brief. Musk nodded respectfully. Mr. Chief Justice, I intend to address precisely those questions, but I believe the court must first understand the technological context that makes traditional legal frameworks insufficient. Roberts's jaw tightened visibly. We are quite capable of understanding technological context, Mr. Musk. What we require is sound legal reasoning, not a lecture on innovation from someone with no formal legal training. The comment, unusually dismissive for the typically reserved Chief Justice, rippled through the courtroom. A reporter from the Washington Post quickly typed notes on her phone. The confrontation that had begun with tension was now approaching open hostility, with the highest judge in the land seemingly determined to put the tech billionaire in his place. What neither man knew was that the next 30 minutes would transform not just this case, but potentially the entire framework of First Amendment jurisprudence in the digital age. Mr. Chief Justice, with respect, Musk began, his voice calm but firm. My lack of formal legal training may actually be an advantage in this case. I'm approaching these constitutional questions without the constraints of conventional legal thinking, constraints that developed in an era before digital speech platforms existed. Justice Samuel Alito leaned forward. Mr. Musk, are you suggesting that established First Amendment jurisprudence is obsolete? Not obsolete, Justice Alito. Incomplete. Musk turned a page in his notes. The court's existing frameworks assume communication channels with physical or practical limitations. Digital platforms operate without those limitations, creating novel constitutional questions, Justice Sonia Sotomayor interjected. But Mr. Musk, your company's made conscious decisions about your algorithmic designs. The government isn't regulating your speech. It's addressing how your business practices affect public discourse. Musk nodded appreciatively at the question. Justice Sotomayor, that distinction is precisely what I hope to address. Our algorithmic choices are themselves expressive conduct. When the government mandates changes to those algorithms, it compels speech in a way the founders never anticipated, but would recognize as constitutionally problematic. Chief Justice Roberts shook his head, visibly frustrated. Mr. Musk, the court has heard variations of this argument before. What you're describing as novel is simply a technological application of established principles, unless you have something substantively new to add. I do, Mr. Chief Justice, Musk interrupted, causing several justices to raise their eyebrows at the breach of protocol. And if the court will permit me 5 uninterrupted minutes, I believe, I can demonstrate why this case requires a fundamental reconsideration of how we interpret the First Amendment. Robert's expression darkened. Mr. Musk, this court operates according to established procedures. You don't dictate the terms of oral argument. I apologize for my phrasing, Musk replied smoothly. I'm simply requesting the court's patience. As I present evidence that directly addresses Justice Sotomayor's excellent question, Justice Amy Coney Barrett spoke for the first time. I'm interested in hearing this evidence, Chief Justice. Roberts glanced at his colleagues, several of whom nodded slightly. Very well, Mr. Musk. Proceed, but remain focused on legal arguments. Musk reached below the lectern and produced a tablet computer. With the court's permission, I've prepared a demonstration. This is highly irregular, Roberts said sharply. The court does not typically allow technological demonstrations during oral argument. Justice Ketanji Brown Jackson leaned forward. Chief Justice, given the nature of the case, perhaps we should make an exception. I'm curious about what Mr. Musk wishes to show us. Roberts's frustration was plainly visible, but he nodded curtly. Proceed, Mr. Musk, briefly. Musk activated the tablet, which projected onto the large screen normally used for case materials. What I'm showing the court is a live demonstration of how algorithmic speech functions. This split screen shows identical user profiles interacting with the same content using two different algorithmic frameworks. For the next 4 minutes, Musk guided the justices through a technical but surprisingly clear explanation of how content moderation algorithms functioned as both technological systems and expressive mechanisms. He demonstrated how government-mandated changes would fundamentally alter the communicative nature of the platforms in ways that traditional media regulations never could. The government's regulations don't simply address how we operate. They dictate what our platforms communicate, and how they communicate it, Musk explained. This isn't comparable to regulations on broadcast media or print publications. It's more akin to the government dictating how a newspaper must edit its articles or how a book publisher must arrange chapters. Justice Neil Gorsuch leaned forward. Mr. Musk, your demonstration is certainly illuminating from a technological perspective, but the legal question remains. Why shouldn't the government have regulatory authority over platforms that have become essential public forums? Musk smiled slightly, as if he had been waiting for precisely this question. Justice Gorsuch, that brings me to the core of my argument. I've prepared a legal analysis that I believe answers this question definitively. He produced a document and requested permission to distribute it to the justices. Roberts, increasingly frustrated but aware of his colleague's interest, reluctantly agreed. As the justices reviewed the document, their expressions changed noticeably. Justice Kagan's eyebrows rose in apparent surprise. Justice Kavanaugh leaned over to whisper something to Justice Thomas, who nodded thoughtfully. Mr. Chief Justice, members of the court, Musk continued, what you're reviewing is a comprehensive analysis of 73 Supreme Court decisions dating back to 1919. I've identified a consistent pattern in the court's approach to new communication, technologies that suggests a clear constitutional principle. When communication methods evolve, the court has consistently extended First Amendment protections before allowing government regulation, not after. Justice Roberts examined the document with visible surprise. Mr. Musk, did you prepare this analysis yourself? I did, Mr. Chief Justice. With assistance from AI tools, I designed specifically for legal research, but the analysis and conclusions are entirely my own. This is... Roberts paused, seeming to reconsider his words. This is unexpectedly thorough. Musk nodded respectfully. Thank you, Mr. Chief Justice. If I may continue, I believe this historical pattern reveals something crucial about how the court has interpreted the First Amendment across technological transitions, from print to radio, from radio to television, from television to early internet. In each case, the court established protection first, then allowed careful regulation only after the expressive medium had constitutional security. The tension in the courtroom had transformed. What had begun as confrontation was evolving into something more complex, a reluctant engagement with ideas that, whatever their source, clearly warranted serious consideration. Justice Roberts set down the document, his expression now thoughtful rather than dismissive. "Mr. Musk, you've certainly presented a more substantive legal argument than I anticipated. However, he was interrupted by Justice Clarence Thomas, who rarely spoke during oral arguments. "Mr. Musk," Thomas said, his deep voice commanding immediate attention. "Your analysis indicates that you've identified a pattern in our jurisprudence that even our own clerks haven't synthesized in quite this way." "I find that remarkable coming from someone without formal legal training." Musk nodded respectfully. "Justice Thomas, sometimes an outside perspective allows one to see patterns that might be less visible to those within a system." Robert's frustration had visibly evolved into something more complex, a reluctant recognition that the man he had dismissed might actually be presenting something worthy of serious consideration. "Mr. Musk," Roberts said, his tone noticeably different, "I believe the court would benefit from hearing the remainder of your argument without further interruption. Please continue." The atmosphere in the courtroom had transformed completely. What had begun as an uncomfortable confrontation between the Chief Justice and a tech billionaire had evolved into something far more substantive, a serious constitutional dialogue with potentially historic implications. For the next 17 minutes, Elon Musk presented what several legal observers would later describe as one of the most innovative First Amendment arguments heard before the Supreme Court in decades. Gone was the tech showman, replaced by a surprisingly methodical constitutional theorist who connected historical court precedents with technological realities in ways that visibly engaged all 9 justices. "The fundamental question before this court," Musk continued, displaying a series of carefully constructed slides that illustrated his legal reasoning, "is whether algorithmic curation of content constitutes protected speech. I submit that the court's own precedents, when viewed holistically, provide a clear answer. Yes." Justice Kagan, known for her sharp questioning, leaned forward. "Mr. Musk, your analysis of our precedents is impressively thorough, but there's a critical distinction you haven't addressed. Traditional media companies make editorial decisions about content they themselves produce or commission. Your platforms primarily organize and amplify content created by others." Musk nodded respectfully. "An excellent point, Justice Kagan, but I would direct the court's attention to Miami Herald Publishing v. Tornillo, where this court held that even decisions about which third-party content to include, in that case political responses, in newspapers, constituted protected editorial judgment." He tapped his tablet, bringing up the relevant passage from the 1974 decision on the courtroom screen. The court wrote that the choice of material to go into a newspaper constitute the exercise of editorial control and judgment. Our algorithmic decisions are the digital equivalent. We don't simply transmit others' speech. We make millions of editorial judgments about how that speech is organized, contextualized, and presented. Justice Roberts, who had been silently taking notes, looked up. "Mr. Musk, even accepting your analysis of our precedents, there remains the practical question of market power. Your platforms have unprecedented reach and influence. Shouldn't that create different constitutional considerations?" "A fair question, Mr. Chief Justice," Musk replied. He advanced to a new slide showing a statistical comparison. "I've analyzed every case where this court has considered market concentration in First Amendment contexts. In 27 decisions, over 6 decades, the court has consistently held that the size or influence of a speaker does not diminish its constitutional protections." He paused, making eye contact with Roberts. "In fact, Mr. Chief Justice, I would direct the court's attention to your own opinion in Citizens United, where you joined the majority in affirming that the identity or power of a speaker doesn't diminish. First Amendment protections, an audible murmur spread through the courtroom. Musk had just effectively used Roberts' own reasoning against him, but had done so with such precision and respect that it came across as intellectual engagement rather than confrontation. Justice Barrett spoke up. "Mr. Musk, your legal analysis is surprisingly sophisticated, but there's still the matter of practical application. If we accept your framework, what limits would remain on government regulation of digital platforms?" "An essential question, Justice Barrett," Musk replied. He advanced to a slide titled "Constitutional Boundaries for Digital Regulation." "I'm not arguing that platforms should be free from all regulation. Rather, I propose that regulations must meet 3 criteria to be constitutionally permissible." He enumerated them clearly. First, they must be content neutral. Second, they must address demonstrable harms, not theoretical concerns. Third, they must be the least restrictive means of addressing those harms. He turned to a new slide showing specific examples. For instance, regulations requiring transparency about algorithmic decision-making would likely be constitutional under this framework. Requirements for specific content outcomes would not. Justice Kavanaugh, who had been taking extensive notes, looked up. "Mr. Musk, you've presented a nuanced constitutional argument that clearly required significant legal research and analysis. May I ask why you chose to argue this case personally, rather than relying on experienced Supreme Court advocates?" The question seemed to momentarily catch Musk off guard, the first sign of anything less than complete preparation he had shown. He paused briefly before responding. "Justice Kavanaugh, I believed this case required someone who deeply understands both the technological realities and the constitutional principles at stake. While I have enormous respect for the Supreme Court bar, I felt personally obligated to present these arguments." He glanced briefly at Chief Justice Roberts before continuing. "Additionally, I wanted to demonstrate my personal commitment to these principles. This isn't simply a business matter for me. It's about fundamental questions of free expression in the digital age." Roberts, who had been taking notes throughout Musk's presentation, set down his pen. His expression had transformed completely from the dismissive frustration he had shown earlier. He studied Musk for a moment before speaking. "Mr. Musk, I owe you an apology," he said, causing a ripple of surprised murmurs throughout the courtroom. "I made assumptions about your legal capabilities based on your lack of formal training. Your presentation today has been not just adequate, but genuinely illuminating." The admission, unprecedented from the typically reserved Chief Justice, created a moment of profound silence in the courtroom. "Thank you, Mr. Chief Justice," Musk replied simply. "I appreciate your willingness to engage with these arguments on their merits." Roberts nodded, then turned to the Solicitor General, who was representing the government. "General Williams, you'll have 30 minutes for rebuttal, but I think you'll agree that Mr. Musk has presented arguments that require serious consideration." The Solicitor General rose, visibly recalibrating her approach. "Yes, Mr. Chief Justice. If I may request a brief recess to review some of the precedents Mr. Musk has highlighted." "Granted," Roberts replied. "The court will take a 15-minute recess." As the justices rose to exit, several of them glanced at Musk with expressions ranging from surprise to grudging respect. Justice Thomas actually nodded slightly in Musk's direction, a rare gesture of acknowledgement from the court's most reserved member. In the gallery, legal correspondents were already typing frantically on their phones. What had begun as a potential humiliation for a tech billionaire out of his depth had transformed into something entirely different, a moment where conventional wisdom about legal expertise had been upended in the nation's highest court. Supreme Court's decision in Platform Innovation Corp. v. Federal Communications Commission was released 3 months later, on a warm Tuesday morning in June. The 6-3 majority opinion, authored by Chief Justice Roberts himself, sent immediate shockwaves through both legal and technology circles. In considering whether content curation algorithms constitute protected expression under the First Amendment, Roberts wrote, "We must adapt our constitutional principles to modern technological realities without abandoning their essential character." The opinion continued, "We hold today that algorithmic curation of third-party content constitutes protected editorial judgment when it reflects expressive choices rather than purely functional operations. Accordingly, government regulations that mandate specific content outcomes or algorithmic designs implicate core First Amendment concerns and must survive strict scrutiny." Legal commentators immediately recognized something remarkable in the opinion. It incorporated several of the analytical frameworks Musk had presented during oral arguments, even adopting similar language in key passages. On CNN, legal analyst Jeffrey Toobin appeared visibly amazed. "What we're seeing here is extraordinary. The Chief Justice has essentially validated Elon Musk's constitutional theory. The court has created a new framework for digital speech that reflects many of the arguments Musk personally presented." The Washington Post's Supreme Court correspondent published an analysis noting that Roberts had cited several of the historical precedents Musk had highlighted, cases that hadn't appeared in the original briefs but had emerged during Musk's presentation. Chief Justice Roberts' majority opinion reflects a surprising intellectual humility, the article noted. He has incorporated novel legal reasoning from a non-lawyer who managed to identify patterns in the court's own jurisprudence that had previously gone unrecognized. Within hours of the decision's release, Musk held an impromptu press conference on the steps of the Supreme Court. Gone was the confrontational tech disruptor. In his place stood a thoughtful advocate for constitutional principles. "Today's decision isn't about me or my companies," Musk told the assembled reporters. "It's about establishing clear First Amendment protections for digital expression before allowing government regulation, exactly the pattern the court has followed with every new communication technology throughout American history." When asked about his personal victory over the Chief Justice who had initially dismissed him, Musk was surprisingly gracious. "Chief Justice Roberts demonstrated exactly what we want from our judiciary, a willingness to engage with arguments on their merits, regardless of their source. His intellectual integrity in considering these ideas, despite his initial skepticism, reflects the best traditions of the court. The fallout from the case extended far beyond the immediate legal questions. Law schools across the country quickly incorporated the case into their constitutional law curricula. Harvard Law School announced a new course on technological innovation and constitutional interpretation, with Musk invited as a guest lecturer for the inaugural class. Perhaps most surprisingly, Chief Justice Roberts himself addressed the case during a judicial conference the following month. In remarks that quickly went viral, he reflected on the experience with unusual candor. "In my 17 years on the court, I've learned that wisdom can come from unexpected sources," Roberts told the assembled judges. "The platform innovation case reminded me that our legal system benefits when we remain open to novel perspectives, even, perhaps especially, when they challenge our assumptions about expertise and authority." He added with a rare touch of humor, "It seems that disruption can occasionally be a positive force, even in institutions as tradition-bound as the Supreme Court." The relationship between Roberts and Musk evolved in ways no one could have predicted. 6 months after the decision, they appeared together at a Stanford Law School symposium on technology and constitutional rights. Their discussion, Roberts representing judicial caution, Musk advocating technological innovation, demonstrated a remarkable intellectual rapport that had emerged from their courtroom confrontation. "What I've come to appreciate about Mr. Musk's approach," Roberts told the audience, is that he approaches legal questions with both respect for precedent and willingness to reconsider first principles. That balance is something every jurist aspires to achieve. Musk, for his part, showed newfound appreciation for legal institutions. Working through these constitutional questions has given me profound respect for the careful way the court balances competing values. There's a wisdom in that methodical approach that technologists would do well to understand. The case transformed not only First Amendment jurisprudence, but also the relationship between the technology sector and legal institutions. Tech companies began hiring constitutional scholars alongside engineers, recognizing that their work increasingly implicated fundamental rights and principles. Law firms established specialized practices, combining technological expertise with constitutional advocacy, creating a new hybrid field that bridged the gap between Silicon Valley and Washington. Several technology executives followed Musk's example by obtaining legal training, recognizing that the future would require leaders who understood both code and constitutional principles. For ordinary Americans, the case represented something more fundamental, a reminder that in a constitutional democracy, even the most powerful institutions remain accountable to reasoned argument. The image of the world's richest man successfully advocating before the nation's highest court, not through wealth or influence, but through careful legal reasoning, offered a powerful civics lesson about the American system at its best. 1. Year after the decision, a documentary titled The Unlikely Advocate, Musk, Roberts, and the Future of Digital Rights premiered at the Sundance Film Festival. It featured interviews with legal scholars, technology experts, and several of the justices themselves, exploring how the unexpected courtroom confrontation had transformed constitutional understanding in the digital age. In the film's most powerful moment, Chief Justice Roberts reflected on what the case had taught him about preconceptions and expertise. "I've spent my career in legal institutions," he said, "surrounded by people with similar training and backgrounds. What Mr. Musk demonstrated is that sometimes it takes an outsider to help us see our own principles in a new light." The film ended with a split-screen image. On one side, Chief Justice Roberts in his judicial robes, representing the enduring institutions of American law. On the other, Elon Musk in his characteristic casual attire, embodying technological disruption. Between them appeared a quote from Justice Louis Brandeis, written nearly a century earlier, but newly relevant in the digital age. "If there be time to expose through discussion the falsehood and fallacies, to avert the evil by the processes of education, the remedy to be applied is more speech, not enforced silence." The case of Chief Justice Roberts and Elon Musk had demonstrated that even in an age of technological upheaval, the Constitution's fundamental principles remained vital, not as rigid constraints, but as living concepts capable of adaptation to realities their authors could never have imagined. Thank you for watching this extraordinary story of legal confrontation and unexpected brilliance. Don't forget to like and subscribe for more in-depth analysis of the most consequential Supreme Court cases shaping our constitutional rights. Share your thoughts in the comments. Do you think non-lawyers should be allowed to argue before the Supreme Court? We'll see you in the next video.